In 2017, a jury at the Old Bailey found Robert Rhodes not guilty of murdering his wife. In England and Wales, that is supposed to be the end of it. An acquittal is final. The state gets one attempt, and if it fails, it does not get another. 8 years later, Robert Rhodes stood trial for the same killing, in front of a different jury, in a different court. This time they convicted him. The evidence that freed him in 2017 and the evidence that convicted him in 2025 came from the same person. Dawn Rhodes was 38 years old. She was killed in the kitchen of the family home near Redhill, in Surrey, on the 2nd of June 2016. The public record of her life is thinner than it should be, and there is a reason for that. For 9 years, the only account of how she died was her husband's account, and in it she was the aggressor. The judge who eventually sentenced him said he had robbed Dawn of her good name, and that this had increased the pain caused to her family. What the court did establish about her, it established at the end rather than the beginning. Mrs. Justice Ellen Bogan described her as a warm and vibrant woman whom Rhodes had violently deprived of life. Her mother said afterwards that Dawn's voice had been heard for the first time. Read that sentence again, because it is doing something specific. Dawn died in 2016. Her mother is describing 2026. For the decade in between, the version of Dawn Rhodes that existed in the official record was not a version her family recognized, and there was no mechanism available to them for changing it. That is unusual. In most murder cases, the victim's account is missing because they are dead, and everyone understands that. Here it was missing because it had been actively replaced by sworn evidence in a courtroom that a jury accepted. Robert Rhodes was a carpenter. He and Dawn had a child who was under 10 years old in 2016 and who cannot be named. Reporting restrictions are in place. Throughout this film, that person is referred to only as they were referred to in court, X. One more thing about the shape of this case before we go into it. There are 3 separate accounts of what happened in that kitchen. The one Rhodes gave in 2016 and repeated on oath in 2017. The one he gave on oath again in the family court in 2018, and the one that emerged in 2021 from the only other person who was in the house. 2 of those accounts are the same account. The third is the reason he is now serving a life sentence. The sentencing remarks record where this begins, and it begins with a card. On Christmas Eve 2015, Rhodes took a card from Dawn's handbag and opened it. While she slept, he read the messages on her phone. He then confronted her with what he had found, and she told him she had formed a relationship with someone else. By early 2016, the marriage was over in every sense that mattered. Rhodes filed for divorce, and then, over a period of months, he planned to kill her. That word matters, and the court was specific about it. This was not a man who lost control during an argument. The planning ran for months, and it was detailed enough to include what the scene should look like afterwards, and what the only witness should say about it. Most domestic homicides are not like this. The pattern researchers describe most often is escalation, a relationship that deteriorates, violence that increases, and a final incident that is severe but not designed. Prosecutors in those cases are usually arguing about intent in the moment. This case is the other kind, and it is rarer. The intent was not formed in the moment. It was formed months earlier and then rehearsed. The court heard what he called it when he explained it to X. He called it our plan. He described the object of it as getting rid of Mummy. On the 2nd of June 2016, Dawn came to the house to see her child. What happened next was designed to look like something else. X was told to ask Dawn to close her eyes and hold out her hands, as though she were about to be given a surprise. X then left the room. Rhodes attacked her with a knife. Her throat was cut, severing all the structures in her neck. He then set about building the scene. He inflicted a wound on X's forearm. He wanted X to inflict wounds on him, and X could not do it, so he did some of it himself. At 34 minutes past 7 that evening, X made the 999 call. On that call, and to the officers who arrived, Robert Rhodes said that his wife had attacked him and their child with a knife, and that he had acted in self-defense. He told police Dawn had hit him twice on the back of the head. Police found Dawn on the kitchen floor. Consider what that scene looked like to the officers who walked into it. A man with injuries, a child with a wound to the forearm, a woman dead on the floor, a knife, and a father and child giving the same account of what had happened. There is no obvious way from inside that room on that evening to arrive at any other reading of it. The case that reached the Old Bailey in 2017 was not a weak case for the prosecution. A woman was dead in her own kitchen. Her throat had been cut. But the physical evidence was consistent with what Rhodes said. He had wounds. The child had a wound. There was a knife. There had been an argument. And the only other witness in the house was a child who told police, clearly and consistently, that their father's account was true. A jury heard all of it and acquitted him. It is worth being careful here, because the easy version of this story is that 12 people got it wrong. That is not quite what happened. The jury in 2017 was asked whether the prosecution had proved, so that they were sure, that Rhodes had not acted in self-defense. They had a defendant with injuries, a child witness supporting him, and no evidence at all that any of it had been staged. On the evidence they were given, the verdict was not unreasonable. The evidence they were given was the problem, not the people weighing it. It is also worth noticing what the prosecution in 2017 did not have. They had no motive they could evidence beyond a failing marriage, which describes a great many people who do not kill anyone. They had no prior violence on record. Rhodes had no previous convictions for it. And the judge in 2026 would note that this was his only mitigation. They had no witness who contradicted him, because the only other person in the house was supporting his account. They had a dead woman and a story that fitted the room. Robert Rhodes walked out of the Old Bailey in 2017, having been acquitted of murder, and under the law as it had stood for centuries, that would have been permanent. He did not stop. While he was on bail awaiting the first trial, during supervised contact, he continued to give X instructions about the account they were to give. In 2018, in the family court, he gave evidence he knew to be false. He would later be convicted of perjury for it, alongside a second count of perjury for the evidence he had given at the Old Bailey. There is a detail in the perjury counts that is easy to skim past. He was convicted of perjury twice, once for the Old Bailey in 2017, and once for the family court in 2018. The family court is not a criminal court. It decides where children live and who they see. Rhodes gave false evidence there, a year after being acquitted, in proceedings concerning the same child he had coached, about the death of that child's mother. For 4 years after his acquittal, the version of Dawn Rhodes that existed on the record was the one her husband had invented. A woman who had picked up a knife and gone for her family. That is a specific kind of harm, and it is worth naming. A murder takes a person's life. What Rhodes did after the murder took her account of it and replaced it with his own, in a court, on oath, where it became the official version. She could not correct it. The only other person who could was a child he had spent years instructing. In November 2021, X told a therapist what had actually happened. Then they told the police. It is worth stopping on what that required. By 2021, the account had been held for 5 years. It had been given to police at the scene as a child, then given again in a criminal trial that ended in acquittal, then supported through family court proceedings. Every adult who mattered had accepted it. It had worked. Changing it meant saying, to a therapist first and then to police officers, that everything previously said had been untrue, including in a courtroom, and that the person who had made it untrue was their surviving parent. The judge would later pay tribute to X's fortitude. The prosecutor said none of us can begin to imagine what Rhodes had put them through over a period of many years. The account was this. The killing had been planned for months. Rhodes had called it our plan. The wounds on Rhodes, and the wound on X's forearm, had been deliberately inflicted by Rhodes to support a story he had already worked out. X had been coached, before and after, into an account that was not true, and had been kept in it for 5 years. The evidence that had produced the acquittal had come from a child who had been manipulated into giving it. That is the fact the second trial turned on, and it is worth sitting with, because it means the thing that made the first verdict wrong was the same thing that eventually made it possible to overturn, except that under the law as it had stood since the 12th century, it was not possible to overturn it. The rule against double jeopardy is one of the oldest principles in English law. If you are acquitted, you cannot be tried again for the same offense. Not with better evidence, not with a confession, not with anything. The reasoning behind it is not sentimental. The state has vastly greater resources than any individual. If it could keep trying until it got the verdict it wanted, an acquittal would mean nothing, and a person could be pursued indefinitely for something a court had already said they did not do. The rule exists to make a verdict mean something. That changed in 2003. The change did not come out of nowhere, and it is worth knowing where it did come from. In 1999, the inquiry into the murder of Stephen Lawrence reported 3 men had been acquitted of that killing in 1996, in a private prosecution brought by the Lawrence family, after the judge directed the jury that the evidence was insufficient. Under the law as it stood, that was final, regardless of what might emerge later. Sir William Macpherson's report recommended that the double jeopardy rule be reconsidered, and that prosecution after acquittal should be permitted where fresh and viable evidence was presented. He also predicted what such retrials would look like if the change were made. They would be exceptional, he said, and safeguards would be essential. The Law Commission examined the question and reported in March 2001. It recommended an exception, and it recommended confining that exception to murder. Parliament went further. Part 10 of the Criminal Justice Act, 2003, applied the exception to a list of around 30 serious offenses set out in Schedule 5. The provisions came into force in April 2005. There is a loop in that history worth noticing. In 2012, Gary Dobson was convicted of the murder of Stephen Lawrence at a retrial made possible by the law that Stephen Lawrence's case had produced. So an acquittal can now be quashed and a retrial ordered. But the bar is deliberately high, and it has 4 parts. There must be new and compelling evidence. New means it was not available at the original trial. Evidence that existed and was missed does not qualify. The Court of Appeal must be satisfied that quashing the acquittal is in the interests of justice. The Court of Appeal, not the prosecution, makes the decision, and the application requires the personal consent of the Director of Public Prosecutions. Not a delegate. The Director. The Crown Prosecution Service describes applications under this provision as exceptionally rare, and says they are made only in the most serious of cases. It is worth understanding why the bar sits where it does, because it is not there to protect people like Robert Rhodes. It is there because the alternative is worse. A prosecution service that can reopen any acquittal it is unhappy with is a prosecution service that never really loses, and a verdict from such a system does not protect anyone. The high bar is the price of the exception existing at all. In 2024, the CPS Appeals and Review Unit made one, in the case of Robert Rhodes. The Court of Appeal quashed the 2017 acquittal and ordered a retrial. It ran for 8 weeks at Inner London Crown Court. The jury that heard it was doing something unusual. They were not only deciding whether Robert Rhodes killed his wife, they were, in effect, examining a verdict that another jury had already reached, on much of the same material, with one piece of it now completely reversed. On the 12th of December 2025, they returned unanimous verdicts on every count. Murder. Child cruelty, for the wound he inflicted on X. Perverting the course of justice, for the injuries he caused to himself and to X, and for manipulating X into inflicting injuries on him. And 2 counts of perjury, for the evidence he gave at the Old Bailey in 2017 and in the family court in 2018. When he was arrested for the murder a second time, Rhodes said he had thought this would come back to bite him. He was sentenced on the 16th of January 2026 by Mrs. Justice Naomi Ellen Bogan. He refused to leave his cell to attend. His barrister told the court that he maintained his innocence and had refused to come. The judge called him a coward. She described what he had done as wicked and callous acts, which had had a devastating and divisive effect on Dawn's family and on his own. Life imprisonment, with a minimum term of 29 years and 6 months, less the 590 days he had already spent on remand. Concurrent terms of 6 years and 9 months for the child cruelty and for perverting the course of justice, and 7 years for both counts of perjury. The judge noted that his lack of previous convictions for violence was his only mitigation, and that in the circumstances it could be of very limited effect. X gave a statement to the court. They said the scar Robert Rhodes left when he sliced open their forearm would never go away, and that it was a constant reminder of what he had done to them. They said he had spent years gaslighting them, parading around as a survivor, while destroying them and their mother. And they said that they lost their father that night, too. There is a version of this story that is about a clever man who nearly got away with it, and there is a lot in the record to support it. He planned it for months. He built a scene. He held a line under oath twice, in 2 different courts, and he is still holding it now. But that version misses what the case actually demonstrates. The system worked exactly as designed in 2017. The police investigated. The prosecution brought the case. 12 people heard the evidence and reached the only conclusion that evidence supported. Nobody was negligent. Nobody cut a corner. And it produced the wrong answer, because the evidence itself had been manufactured, and the person who supplied it was a child who had been told what to say by the person on trial. There is no procedure that catches that. No amount of care in the investigation. No better cross-examination. No more diligent jury. The only thing that could ever have corrected it was the person who had been coached deciding, years later, to say something different. That is not a system working. That is a system being rescued. The law changed in 2003 to allow for exactly this, for the rare case where an acquittal turns out to have been built on something that was not true. It is used sparingly, and it should be. An acquittal that can be revisited whenever the prosecution finds something new is not an acquittal. But it exists, and in this case it was used, and it took 9 years. Dawn Rhodes was 38. For most of the time since her death, the official record said she had picked up a knife and attacked her family. It does not say that anymore.